family
Welcome back to
trips.
the Law&Crime Network. I'm Heather Hansen. We're continuing to cover this George Burch case, and it just started this morning with openings and few witnesses. We've heard from two people, a minor who is testifying right about now, and the reason that we're not live in the courtroom, and another gentleman who discovered the body in this case. But that is really just the beginning. So I want to bring in our fabulous guest, our frequent guest here, Julie Rendelman. Hi, Julie.
How are you?
I am fabulous. How are you?
Oh, fabulous. That's good.
I'm
almost fabulous. I'm almost fabulous.
Fabulous for a Monday. So you've been paying attention to what happened this morning with the openings, and I know that you've been paying attention to this case. I saw that you tweeted something about this Fitbit testimony that we're going to be hearing.
Right.
Yeah, so let's start, before we get to the Fitbit, which I could talk about all day long.
Right.
Let's talk a little bit about the openings. What did you think about both sides' openings today?
I always hate, picking on either side because I was a prosecutor for a long time and I'm a defense attorney now. But I will say this. I thought the prosecutor did a much better job than the defense. That was my position. I didn't think the prosecutor was overly passionate. I would have liked to see a little more organization. But I think he did lay out clearly for the jury the DNA evidence that established that Burch was the true killer, and kind of explained why it was that the boyfriend was the initial target of the investigation. So I thought he did a good job laying that out. The defense, however, I didn't feel so good about their opening statements. And the reason I didn't is I felt that they laid out a great argument for why their own client was guilty. And the reason I felt that way was because I felt that they were kind of establishing that the victim's boyfriend didn't really have that much of a motive to kill her and didn't really have an opportunity. It almost seemed like he was more interested in partying that night than he was as to where his girlfriend was, who seemed to be missing. And so I just felt like they were missing something in regards to kind of their approach to establishing reasonable doubt as to why their client was not the person who was guilty. But
I agree with you, and I felt like they had a lot to work with because they had, the fact that the police first arrested the boyfriend, Doug Detry is his name, and the fact that there is at least a motive, arguably, because he was fighting with Nikki Van der Hayden, the victim in this case, and the story that the defense wants to tell, that George Burch was having sex with Nikki and that the boyfriend came along, I mean, that certainly establishes motive.
Right.
And it's a story that could be believable if the jury wants to believe it.
Correct.
But I don't think the defense laid it out in the best possible way.
See, now to defend the defense, I will say that they're probably smart in not going into too many details as to what their client will eventually be testifying to.
Well, and that's a big difference in this case than many of the other cases that we cover, because as you just said, he's going to be testifying.
He has to testify.
That's right. And so because of that, and this is something that I debate with my associates at my office all the time. There's certain times that you are arguing to a jury or questioning a witness that you don't want to show your hand. Right. That you want to hold some cards close to the chest for certain reasons. So here, in the opening, you don't want to tell the prosecutor everything your client's going to say on examination. They may have some clue, but every last detail, because you don't want them to be prepared for it. So you have to be really careful and sort of walk a tightrope.
Right, and you also may not know exactly what you're going to say, so you'll have to be really careful in not having the jury have expectations about what his testimony is going to be. Yeah. So I do understand that they're not going to go into the details of what their client's going to say. However, it doesn't seem to me, based on how the opening went for the defense, that they laid out a good basis for why Doug, I keep forgetting his name. Doug would be the person who killed her versus their own client.
Well, did you see, there is so much, I mean, I could have read about this case forever before I came in here today. Did you see that there's an allegation back in February, the February before the murder, where Doug was actually touching his sister-in-law, or his sister-in-law
inappropriately, and he was arrested for that. Yes. There's, by the way, on both sides, there seems to be, it's almost, I think the other one was involved in a hit and run.
Well, the other one, so George Burch was tried for murder in the 1990s and acquitted, but that murder was a lot different. That allegation of murder was a lot different than this one, in that had to do with a gang, and he was actually kept in jail for a little bit of time. The person who was murdered in that case was the leader of a gang. But there's certainly going to be, in many ways, Julie, as I was looking at this case, I thought, who has the most difficult job in this case? the judge.
Right.
There's a lot.
Figuring out what to keep in and what to keep out.
Yeah.
And I think that it is interesting because if I'm correct, I believe that the prosecution and the defense agreed that they would the prosecution would allow the defense to bring in kind of the evidence against Doug as long as the defendant took the stand.
Yeah.
And so that's interesting for you to get both sides to agree without the judge
Right.
having a say in what goes on. So it seems to me for the very near future that the defense and prosecution have a
deal?
A deal in terms of going forward, which is rare, when you're dealing with a murder case.
It's rare, and it's also great news for this poor judge, because when you make a deal like that, and I sometimes do, if I have motions in limine or motions to preclude certain evidence, and the other side has motions to preclude certain evidence, we'll sometimes sit down and say, okay, I won't bring this in if you don't bring that in, and if you don't say this, then we won't say that. And that the judge loves, because then there's no appellate issue.
Right.
If you come to a deal, you can't then say, I didn't like the deal that I agreed to.
Right.
But if the judge has to rule on every one of those motions, then you can bring that up in an appeal.
Absolutely, and I think the judge probably would have ruled the same way because it is speculation in regards to Doug's involvement in this death without the defendant taking the stand and establishing to the jury, whether they believe him or not, that Doug did all these things, knocked him out, killed her, forced him to move the body, unless he were to testify. And I don't know that Doug's background or the details of who Doug is are necessarily relevant unless you can establish through the defendant's testimony that he was in fact involved in this.
That's absolutely right, because we have to remember and sort of take a broad picture here. Relevance, we talk about it, but what it means is that it goes to prove something more likely than not. It actually supports, so it can't be something that is just sexy or interesting. I think a lot of our viewers want to hear everything. They say, give us all of it. And that's all interesting and sexy, but it has to actually support an issue in the case in order for it, and the probative value has to outweigh the prejudicial value in order for a judge to say that's something that can come in.
Absolutely, and I think that look, as a judge, you have to be very careful because you have a defendant that's on trial for murder. So the argument is if there's potentially another suspect out there, then the defense should usually be able to pursue that. But you can't just, as a defense attorney, name various people, and make baseless accusations against them, And quite honestly, there's an argument to be made that the mere fact that that Doug was originally arrested it's still speculative because it really doesn't establish clear evidence that Doug had committed a crime.
Right.
It's just kind of the police, quite frankly, as far as I'm concerned, in a rush to judgment, which may have screwed up this case to a bit.
Without a doubt, because don't you think that now puts the prosecutor in a position where they're not only trying to prosecute the case against George Burch, but they're also trying to defend the case against Doug Detry. I keep looking back at his last name. Now, to defend, if you were just defending the case against Doug Detry, it's not that hard. There's no DNA tying him to the crime. And there's no, well, let's talk about the Fitbit data.
Oh God, now we have to get to that Fitbit.
The Fitbit is just, we see more and more of this, and we're going to see more and more of this in the future. Things like GPS of your phone and locating where you are and using that at trial. And then with the Fitbit, there were two reasons that the prosecutors wanted to use the Fitbit data or evidence. One is to establish that Detry was sleeping at the time of the crime. And the other was to establish that he was not walking the steps that would be needed in order to commit this crime.
Right.
Now, only part of that gets in before the jury. Tell us about that.
So the only part that seems to get into the jury is the part about how many steps he did or didn't take, but not in regards to whether or not he was sleeping. And we were talking about this, and I actually had looked it up because I'm fascinated, because I admit that my daughter and I sometimes use Fitbits, and we're always joking how they're inaccurate. I'll walk a certain amount, and it's either too little or too much.
Right.
And there doesn't seem to be a lot of studies there seems to be small studies, but no real analysis of how well Fitbits work. But the one thing that I read that seems to be relevant in this case is the Fitbit seems to be the most reliable when the person who's wearing it is sedentary, when the person's not very active, which is this case.
Right.
And so it's interesting because I'm not sure who's going to testify in regards to how accurate the Fitbit is, but that may help them in regards to kind of establishing that it's more accurate than it would be had he been running around that day. I also do have one other question is, how do they establish, and I'm not sure exactly how Fitbits work, that he was wearing that Fitbit the entire night?
Yeah, there's so much that I'm not exactly sure how it works, but that gets into how judges determine which evidence gets in and which evidence doesn't. I'm actually teaching a class on this next week, so I was like, well, this is perfect. Now I can bring this into the class. But there's something called the Daubert motion, which is where the scientific validity of something has to be testified to by some sort of expert.
Right.
So I would assume that we're going to hear from some sort of a Fitbit expert or some sort of an exercise expert, or a lot of times there's sleep experts, which we'll get to the sleep part in a second, who say this is how Fitbits work, and this is how reliable they are, and this is why this evidence is more probative than not and actually has some value. And then under the rules, the judge gets to listen to these experts out of the presence of the jury and say, you know what? This actually has some scientific data behind it, has some studies behind it. This is an expert who's well recognized in the field, and therefore it's good enough evidence for the jury to hear.
Right.
And then they can also say, they being the judges, you know what? Not going to cut
enough.
it.
Right.
And with this case, this judge, I think it's a man, said, yes, you can hear about the steps, but you can't hear about the sleep. Now, what do you think about parsing that out, Julie? Is it going to be easier said than done?
I think it'll be pretty straightforward. I'm not sure who's going to be testifying to this, and I certainly think that the defense, at least when it comes to the Fitbit, could have a field day in regards to establishing all the things that you're talking about
I'm going to have to interrupt you, Julie, because I think we're back live in the courtroom, ladies and gentlemen. We're going to, maybe we're not just yet. In just a minute, I think we're going to be live back in the courtroom. The minute we are, we'll throw you right back there. But I did interrupt you in talking about establishing through the Fitbit on the defense side all the stuff that they have to
which I think they'll have a field day with it. I think they'll have a good time if they know how to ask those questions in regards to cross-examination. Remember, at the end of the day, it's the jury. It's a weight thing. It's the jury makes a decision based on the credibility of whoever's testifying about the Fitbit as to whether or not that establishes that Doug was where he says he was.
Right. I thought it was really fascinating. For those of us who wear Fitbits, I don't have mine on today, but I actually wear an Apple Watch sometimes. It seems as though the science is pretty good as those studies. You were saying that you don't think it always works, but the study is at least enough that the judge let it in, for steps and for movement, but not for sleep. The judge is not allowing the Fitbit data in for sleep, and that's that's not because the judge likes one thing and doesn't, or for the judge himself, it didn't work for me that night, so it's not going to happen. It's based on hearing from experts or reading studies and having the lawyers submit that information to him one way or the other to determine that. And I looked it up a little bit this morning. It seems that in most courts, they don't allow in the sleep information because for those of you out there with Fitbits, it seems like the sleep part is not as advanced.
Right.
As
the science is not as strong. Right. I guess he parsed out the two. Remember, the aspect that we're talking about is the use of a Fitbit merely is there to establish arguably a lack or reasonable doubt on the part of the defense.
Yeah, I'm going to interrupt you again because now we are live back in the courtroom and we're going to take you right back there, but we'll be back to discuss more about this case next break. Welcome back to the Law and Crime Network. I'm Heather Hansen here with Julie Rendelman, and we are just there's too much in this case. I keep reading more and thinking more about the case. So let's talk first about the defense's story, because I think that we're sort of, at least for me, I'm sort of not seeing the forest for the trees right now because the case is so interesting.
Right.
Tell our audience about the defense's story, and then we can get into some of the sexy side stories.
And the story that I'm telling is not necessarily the story that they said on opening, because I think that they, as we talked about before, they left out a lot of the crucial facts because I think they're waiting for the defendant to testify. But my understanding of what the defense's story will be is that the defendant's claiming that the victim and her boyfriend had an argument that night, that after that argument, the victim had a consensual sexual relationship with the defendant that resulted in them going back to, or at least driving back to the victim's home, and that at some point, the victim's boyfriend, Doug Detry, found out about it, knocked the defendant out, killed the victim while he was knocked out, and when he awoke, she was dead, he was there with a gun to him, and forced him to take the victim to the farm area and drop the body. And so therefore they're saying he had absolutely nothing to do with the murder. that Doug is the person that's responsible and that he merely acted on behest of the actual killer, which is her boyfriend.
Yeah, it's quite a story.
And I'm making that face because
I don't know if the audience saw your face, but your face was pretty clear that you're not so down with that.
That face is clear that I'm not down with that.
Yeah, it's quite a story. It's quite a story. I think that we're showing the court there live. I don't know if we're ready to go back live. Are we ready to go back live, guys? Okay, we're going to throw back and then we'll come back to talk about this interesting case some more. Welcome back to the Law and Crime Network. I'm Heather Hansen, and now we are on a lunch break in this George Burch case, which gives us a good, real break to talk about some of the things that we've started to talk about, Julie. I want to finish this conversation because I think so much of what happens in the courtroom is about optics,
right,
and about stories, and that being a lawyer is in such large part storytelling. And so you were saying that when you are examining a witness, so when you get up to ask questions of a witness, whether it's your own or the other side's on cross-examination, you like to pace.
Well, and pacing, by the way, is not a good thing. I've been yelled at for pacing, but I tend to pace the more excited I get from, especially in cross-examination. I think
like
when
a
you're,
shark.
Yeah, I think when you're opening, I think when you're doing direct examination, you're more likely to stay put, you know, and you probably have more expectations of what your witness is going to say because it's your witness.
Right.
So yeah, I think I'm surprised to see, you know, defense attorneys and prosecutors seated throughout the entirety of both the direct and the cross.
Me too. I mean, as I said, when I first saw it, so my practice, and now I'm tipping off my opponents, I guess, but my practice is they're all watching. I hope not. But there's not much they can do because this is just what I naturally do.
Sure.
If it is a witness that I feel as though is like a frail older woman or someone who's super sympathetic, like a man who's lost his wife or lost his child, and the jury already seems to like this person, and the person, I'm not trying to make the person out to be a liar or attack them, I will question from my seat. In order not to look imposing. I'm also tall, and I don't want to be like in that person's face or in the jury's face.
Sure.
But if I'm cross-examining an expert who's less personal to the jury, and I want to go after him, I will also approach the witness and do a lot of back and forth and a lot of throwing things up for the jury to look at, and try also to not allow that witness to make a connection with the jury. So try to get the eyes back on me.
Absolutely. And it's funny, it also depends on where you're positioned, because a lot of times I'll position myself right next to the jury, so that it's me that they're focused on. Quite honestly, in this situation, every time the defense asks a question, the defendant is right next to them. So I don't want the jury focused on my client's reactions to anything at all.
Right.
It's also interesting because a lot of times in New York courts, we get reprimanded if we don't stand up. We get reprimanded if we don't stand up for objections.
Oh, yeah.
We get reprimanded if we don't stand up when we question witnesses. So I'm surprised to see it. I do find, look, you know, court is the theater.
Yeah.
And I think that there is some passion in being able to stand up and express yourself that seems lacking here. But again, I don't know if it's this judge or who knows?
One way or the other, it seems that it's probably the rules. And the other thing that's interesting about trials that I think people who aren't lawyers wouldn't know is a lot of times the judges give you the rules of their courtroom.
Right.
So like in my courtroom, you must address each other. Like for example, there was one case that I tried in front of a judge who would not let us address each other by our first names.
Right.
And sometimes if you have a lot of cases with the opposing attorney, it might come very natural to you to say, Mark, when you should be saying, you know, Mr. Smith. And you really have to watch that, because when you get reprimanded in front of the jury, they start to, especially if they like the judge, they can sort of be like, what's wrong with this Heather Hansen girl?
It's so interesting. One of my early trials, I kept calling the victim as a prosecutor by his first name. In my opening, the judge made me sit down in the middle because I had to say his first name and his last name. And so he was such a stickler with that he wouldn't allow it in front of the jury. You notice in this case, the defense attorney calls the defendant by his first name.
Yeah.
Some judges don't like that.
Yes,
they don't like that personalizing of the name. So it's interesting, you know, because that's definitely a tactic on the part of the defense to.
It's a psychology thing. You know, the more that you can personalize your client to the jury, and a lot of times you see that in cases where the prosecutor will call the victim by their first name. Here, I haven't heard them refer to Nikki,
just her first name,
yeah,
right.
Nikki was what she went by with her
Right.
family and friends. I have not
They've been
yet
using, I
heard
think,
that.
her full name.
Yeah, her full name.
And I also think it sometimes backfires using in the defense situation, using your client's just first name.
Yeah.
I think the jury sometimes can get turned off and think that you, as the defense attorney, is not really getting what your job is.
Right.
To be, so I think that sometimes it can not be effective.
Completely, you have to pick and choose. Like in the Donald Smith case, that terrible case. If she started calling him Don, it probably wouldn't go over really well.
Right, exactly.
So you really
it's a perfect
need
scenario
to,
where you want to stick with Mr.
Right,
Smith.
absolutely. You really need to look at your case. And again, it's the storytelling part.
Right.
What's the best story and the best way to tell this particular story? These cases can never be a formula. Every case is different. And we see that, this week at Law and Crime Network is a perfect way to see the difference. Because with this George Burch case, you've got a real whodunit in some ways. And so that's going to play out a whole lot differently than the Donald Smith death penalty portion of the case.
Which I don't know. I'm still baffled by what happened with the defense during that trial. So that's a whole other, their opening just still baffles me.
Well,
to what decisions they made.
And let's talk about that in just a minute, because we're going to be back to that case tomorrow, and you and I have not yet discussed it, and there's a lot there. But then we also have the Janet Sollander case, which we're going to show some clips of. I do think that defense opening in the Sollander case was really effective.
I thought it was wonderful.
In fact, in talking to some people here who, as we research these cases, we start to get a sense of what we think. A lot of people said, you know what, after that opening, I was a little bit more reasonable doubt.
And there's nothing better than when you have a defense attorney getting up there and you have attorneys that practice all the time that are so impacted by it. I actually wrote something that said afterwards, they're going to need corroboration of what these kids say in order to really make a strong case, because he had me questioning the credibility of these kids, which was really well done, I thought.
And just sort of circle around on this conversation, one of the things that defense attorney sort of puts himself out there as is a performer. Like on his website and everything, and there is some performance in what we do. I think there's a lot of lawyers who are frustrated actors.
Look, you have to be effective in front of a jury. You have to be liked in front of a jury. And so, I think that, look, a lot of prosecutors and defense attorneys take acting classes in order to be more comfortable in front of, their peers, and also be able to kind of express themselves. So it's not surprising that people view it as such a theatrical situation.
But I want to finish talking about Burch before we get to Donald Smith, because I do want to get your thoughts on that, since I haven't had the chance to talk to you about it. But in the Burch case, one of the things that you pointed out, and again with optics, is the victim, Nikki Vanderheiden. She's really an attractive woman.
Right.
Her partner, Doug Detry, also a very attractive man. And whether we like it or not, people do look at that, juries do look at that. And so you've got this claim that she chose to go off and cheat on her partner with George Burch, who is not the cutest.
Right. And and it sounds like in a sense, it sounds like we're being superficial, but life is superficial, and so when you start to tell a story to the jury and you want the jury to buy it, then you have to be sellable, and part of being sellable is that she would make a decision to go with someone outside of her relationship, and not just go with anyone, go with him. And so I admit, when you start to just superficially, and this doesn't make or break the case at the end of the day, but superficially, a jury is going to possibly look at that and say, would she go willingly with him? And if there's a question as to whether she would, then obviously it favors the prosecution that his story is not truthful. Now, quite honestly, I don't think his story really, so far to me, without hearing it, I know that I'm being premature, is going to add up, but we shall see.
The other piece of that, the other piece of the optics, is that he claims that he was knocked out by Doug Detry. Now, I don't know how tall or big Doug Detry is. We're also, I would assume, going to hear from him in this case, which will also be interesting.
Sure.
But George Burch is 6'7" and 250 pounds. I don't think Doug is that big. And so that's another piece where the jury's going to have to imagine that somehow Doug came upon them, and maybe they're going to say that they were in such a state of passion that he was able to overcome him, because otherwise you're going to have to imagine that this guy was able to knock out great big George Burch enough that he could completely have him unconscious so that he could then kill Nikki. That's
And
a stretch.
I agree with you. And keep in mind, both of us are guessing, and this is just from reports we've heard as to what we believe the defendant will be saying. And we both joked when we talked about the idea of knocking out not just this huge guy, but knocking out anyone is not so easy.
Right.
I mean, and we kind of chuckled that it was almost like those Lifetime movies where you think of like the person coming in, the person takes
Like
the
with a
candlestick,
band,
whack, and they're out. And it just doesn't work that way.
Right.
And it just, you know, so when you even hear that story, you start to almost chuckle because there seems to be some lack of credibility. And maybe he won't go that way. Maybe he'll realize it doesn't make a lot of sense.
Right, maybe he'll
but
watch Law&Crime.
we're gonna. I think the jury's gonna have a little trouble with that story if that's what he's going with.
Yeah, it's a fascinating case. The other part of the case that I was telling you that I had read about is there's some allegations that Doug Detry was doing different types of drugs that evening before the murder occurred. Do you think that that is important in any way to this case? Because the allegation is that he was snorting amphetamines over the course of the night, and that then when he got home, and this I found interesting, just I'm not a parent, but if I was a parent, asked his babysitter for some pot. This is at least the allegation. I don't know.
Right.
I mean, if you're hoping that your babysitter is smoking pot,
I would assume that would not be
it.
happening in our households, but
right.
But nevertheless, this is Doug's household.
Right, in Doug's house. But do you think that any of that, A, gets in and B, matters?
I think it could. I think it could go two ways. One, there could be an argument that because he was so high on drugs that he wasn't in his right mind and was so infuriated by what he found outside, if we're following the defense's argument. There's another argument to be made that all this stuff in his system is what put him to sleep.
Right.
And made him not capable of doing and being involved in this crime. So it really depends on how you're able to spin it.
Not capable of making that Fitbit move, which is
which is what we come back to again, which is, you know, did that Fitbit protect him as his alibi in this case?
Do we all want to be wearing Fitbits as long as we stay innocent?
Yeah, I really cannot wait for that testimony.
Me either, but I do have to say, a lot of times, I've covered cases here at Law&Crime, because when you're in the cases, it's different than looking at them from an outside. A lot of times that testimony, like Fitbit testimony, DNA testimony that I'm excited for, is really dry.
Yes.
Really dry. So I'm hoping they find a way to tell the Fitbit story in a way that's compelling.
I think any DNA evidence and, you know, scientific evidence can be slow moving. But I think in this case, by the way, I don't know how much science is behind the Fitbit, you know, in terms of who's going to testify, you know, if it's someone from the manufacturer or someone who's been studying this, you know, the Fitbit. I mean, I think also keep in mind that the GPS issue is also going to be a big issue because the GPS is what establishes that he's at the various places.
He meaning Burch.
I'm sorry, I apologize.
Right,
Burch being at the various places where parts of this crime were allegedly committed. And so that's going to also, if the you know, look, I guess the defense isn't going to go after it because the defense is saying that their theory matches the DNA and matches. So I don't know that we'll see a big issue about that, but had the defense had a different approach, they might have.
You know, I found it, we were talking about Donald Smith, and I want to go there now, but in comparing the way that I thought the prosecutors did an amazing job with the Walmart video in the Donald Smith case to show us, I mean, talk about a story, those arrows were scary. When you know that, you know how that story ends. So you see the Donald Smith arrow getting closer and closer to the Cherish Periwinkle arrow and then backing off and then getting closer. It's a compelling visual. Whereas in this case with George Burch, what you have in front of the jury is going to be Fitbit data on a sheet, which one of a lawyer's job is to make that as compelling as possible, whether you put that into some sort of a PowerPoint or some sort of an optic visual exhibit that the jury can relate to.
Right.
I thought in the Donald Smith case, they could have just played the video. And for long periods of time, we would not have seen anything. And we're showing it now on the screen. And it's just, I just thought it was awesome. Because when they have, here you go. So then you've got yellow was Cherish Periwinkle, orange was her mother, and blue was Donald Smith. And so he's not in the picture right now. Right. And so for a moment, as I watched this, Julie, I was actually like she's safe. Oh, and now she's not. And it definitely had me in the story as I was like thinking to myself, run, yellow arrow, run.
Right.
You know, it's a really effective way of showing the jury that video.
It's so funny. Even talking about it gives me chills because it really, look, arrow or not, the video is riveting.
Yeah.
But you're absolutely right. The prosecutor took the extra lengths to really hammer it home for the jury where the defendant was in position to where the little girl was, during this whole period of time. So, and it was incredibly effective. It's harder in the case we have with Burch because we don't have video surveillance, so we don't have kind of that, the being able to see exactly where the crime started. So yes, it's more difficult for the prosecution to make it as exciting, I hate to use that word when it comes to murders, as in this case. However, there's different ways to be exciting and effective. One is, on an opening, as I said, he did a good job, but he wasn't as effective as, when we talk about acting, getting the jury pulled into this case and really understanding, how strong the case was. And look, it's a matter, we will see as the case goes on if the crime scene evidence that comes in, is able to kind of establish, clearly for the jury that Burch is the one, and we'll see how strong their case is after that.
It's going to be difficult, and it's going to be a challenge for the lawyers to make that something that the jury just doesn't doze off over.
No, I was going to say, but I have to say, cell phone evidence and Fitbit evidence and GPS evidence can be incredibly exciting.
It can be
when you have data that really shows where a person is at the time the various parts of this crime are being committed. That can really pull a jury in.
Completely agree. It's how it's told. If they turn off the lights and put up just the printout from Verizon, it's not as effective as other ways they might be able to do it.
Exactly.
So we'll see. And the Donald Smith case is a good example of being creative and using video and to really drive something home.
Sure.
Now, we're talking about openings, and I do want to talk to you about the Donald Smith opening because I was flabbergasted. I have to be honest. And I felt for that defense attorney because she gets up and gives this opening saying she's going to cross-examine the mother. And that you might not like it, but this is what we're going to have to do, and this is part of our case, and we are going to have to ask her some tough questions. And then the first witness for the prosecution is the mother, and no cross-exam.
See, now we do know that at the end of the day, Donald Smith didn't want his attorney to cross-examine her, and that's the reason that it went the way it did. My question is, how was the opening where they were going to say that they were going to aggressively cross-examine the mother ever going to establish that Donald Smith wasn't guilty of this heinous crime?
That's right.
That's my question. It's not, they should never think about cross-examining her aggressively because there was nothing to gain from it.
Absolutely.
He was going to be guilty no matter what. So I'm still unsure why she, in a sense, as far as I'm concerned, alienated herself from the jury.
But absolutely. And lost all credibility when her client told her not to do it.
Absolutely.
My only thoughts at the time were he was running the show. So either he told her, I want you to cross-examine her.
Right.
And then changed his mind.
Right.
Or maybe he wanted to be appealing to the jury by saying, no, don't cross-examine her and save himself when it came to the death penalty. It just made no sense.
It didn't make any sense.
Made no sense. And that's hard for me to wrap my head around.
Look, Miss Periwinkle's, Cherish's mother is dealing with the guilt of whatever happened, and I think everyone recognizes that. There was no good that could come from aggressively cross-examining her, quite honestly. I don't think that there's any good that can come from cross-examining her at all. It wasn't going to get them where they needed to be.
We're going to start talking about the Solander case in just a minute, so I'm going to throw you to a clip of the defense opening that we were just raving about, and then Julie and I will sort of break it down.
Good afternoon, everyone. Perspective, word choices, and context. As we learned during the last 3 days, the individuals selected to be jurors are very different, with vastly different opinions and experiences. And that is a good thing. And as you begin to hear information and these allegations, the one thing the system of American justice requires is for you to take everything in. You should remain curious, demand answers to questions that you may have, want to know as much about the circumstances as possible, pay special note as testimony and evidence comes in as to what the prosecutors leave out and don't tell you, who they do not call, what doctors they do not call, what information they don't give you about the Solanders, and Mrs. Solander in particular, the children, their history before they ever came into contact with the Solander family, and Miss Solander's history. All of that is important in a case like this. And as the witnesses come out and documents come out, one after another, we ask you to take notes and take note how that information is presented and how that is really part of narratives, perspective, word choices, and context. Now, what I'm asking you to look for as the evidence comes in is not very different on how you should watch the news or evaluate any story that any child or person gives you. For instance, the same set of facts, uncontrovertible facts, presented on, say, Fox News, may...
I'm going to object. This is supposed to be what the evidence is going to show.
Well, overruled,
Thank you.
but be careful not seeing argument.
Versus what is presented on CNN may serve very different purposes. You have to watch out as you receive the information as to what is verified and what is not, what is innuendo and what is true. And understand, as you hear the evidence, there are advocates who are inclined to believe criminal child abuse from the allegation, and they may offer their expert opinion based on their perspective.
I'm going to object again.
This is the context of Dr. Settle testifying.
All right, overruled.
Thank you.
I don't think it's argument at this point.
It's about how you perceive the information and trying to get information to you without burying. That's what we're trying to do, and that's what we want you to look for. The prosecutors choose their words, and as you hear the evidence, you will hear those words. Punishment, anger, rage, victim, abuse, beaten. You heard it in the opening statement. Why not use the word structure, accusations, concern, good intentions, corrective efforts? I would submit to you, ladies and gentlemen, that the narrative, the word choices are a product of a narrative that assumes the worst in people and will give no context to who Janet Solander is and why she did any of the things that she actually did. Which begs the question, when you come to those witnesses and perceive those witnesses, are you a person who looks for evil as an explanation, or are you a person who comes from a place of compassion, understanding, and a desire to learn all of the circumstances? To do as the American justice system requires, which is to presume throughout the receipt of evidence that any conduct you believe Mrs. Solander committed was not criminal abuse. And that's what I say when I say perspective, word choices, and context as we move through this case together. This is old school PowerPoint. Now, from the onset, I want to go a little out of order and confidently say that you will hear no credible evidence that supports the wild allegation from the adopted Solander children that there was sexual assault. That will be a distraction from the more important business at hand. You will see from the evidence that it has no place in these proceedings, that it simply did not happen, and more than that, it's a word choice. You may have preconceived notions when the prosecutor decided to level a charge of sexual assault against Mrs. Solander, and it probably was a huge shock to learn in the prosecutor's opening statement that the so-called sexual assault was the alleged medical insertion of a catheter on a youngster who was allegedly intentionally withholding urine. So it's word choices, narrative. These are the things we want you to pay special attention to when you hear the testimony of the witnesses and the questions of all counsel. Indeed, and it bears repeating, the presumption of innocent means that the allegation of inserting a catheter is presumed not to happen until or unless the prosecution proves that to you beyond a reasonable doubt. The defense can't prove a negative, nor does the law require the defense to do so. But we can, and we point out during these proceedings, that the false allegation does not have sufficient corroboration or proof. And that holds equally true for the catheters as the outrageous allegation that a pain stick was placed in one of the girl's vagina at one point. So let's go back and start from the start and tell you more about this case than the prosecutors did in the opening. First off, fancy PowerPoint from the government. They can't.
Objection, argumentative.
It was not a fancy PowerPoint.
All right.
And they don't have a single slide about who Janet Solander is, but plenty of innuendo. Did they tell you about her upbringing on military bases?
Judge, I'm going to object and ask to approach.
All right.
In the Army, where she served as an EMT and then as a medical tech. You will hear during the course of this trial that she was a nursing assistant for the Department of Defense for many years. These are public records that could be checked. You will hear about Ms. Solander's mother's death when Janet was 12 years of age from diabetes and her own health problems, including a diagnosis of diabetes and Van Willebrand's disease, which is progressive thyroid disorder. And this information is important, not because we're asking to engender sympathy, but because it paints a picture of a person who developed into a loving, caring parent who knew the value and the importance of taking kids to doctors, to test them early, to figure out what's going on medically or psychologically, if anything, and equally eliminating possible medical concerns. You will hear that Mrs. Solander had no issue raising her 4 biological children. There were no allegations of abuse in any way, that it is not her style. Indeed, I think that we have to concede at this point that all the evidence will show that Janet Solander is a perfect candidate for foster care and went through all of the vetting. And as a foster parent, the Department of Family Services, DFS, and Child Protective Services, CPS, were necessarily involved and evaluated things and did not tell the Solanders that the things that the prosecution is now saying are criminal were in any way wrong. That the government, same government, went into that house, saw things, and didn't say this is criminally liable, but found that allegations were unsubstantiated and found that the techniques, while maybe not orthodox, were not crossing the line into criminal behavior, because they all have an obligation to do that. And the Solanders have a right to rely on those interactions for what's reasonable. Indeed, the Solanders were trained and appropriate and had an appropriate home that had many visitors, including mandatory reporters in the home who endorsed what the Solanders were doing, by failing to say in any way that they needed to stop doing it. And the proof, ladies and gentlemen, is not only did the Department of Family Services keep giving kids to the Solanders, but they encouraged the Solanders to adopt Ava, Amaya, Anastasia. They encouraged them to do it at the quickest point that they could. Heck, the state reimbursed the Solanders for the adoption proceedings. When you look at the charging document, it says that all this abuse began on January 19, 2011, the date of the adoption. You saw a picture, so they're saying that the picture that you were shown of the smiling children at the adoption proceeding, that day just horrific, terrible torture that never stopped for the next 2.5 years started. That day. They're just waiting. That's the narrative. But the evidence will show that Janet Solander did not somehow snap that day on the day of the adoption. That her 50-some-odd years on earth at that point, as a thoughtful, gentle, loving, caring, involved, concerned person, did not end the second the judge signed the piece of paper giving them the adoption. Look at that amended information. You'll see that day is when they're alleging this occurred. The prosecutor suggests in their opening that Janet was just waiting for the second that DFS was not directly involved to do what? Torture these kids, be a completely different person out of the blue. The evidence will not support that. When you receive the evidence, presumably, the question will arise. How does it make sense that an abuser is making all these strides to help these kids in such an open way? That this alleged abuser is making sure all the kids are okay while she's out of town, and that, ladies and gentlemen, is when that nanny came in for the 3-week period. Janet Solander wasn't even there. She had to go care for sick relatives out of town, and she wanted to make sure that Dwight had help. And Dwight gave whatever instructions the nanny is going to talk about, not Janet. They came from Dwight. That's the abuser. That's consistent with the abuser to make sure that the kids are taken care of. The evidence will show that all the doctor's visits, all the exposure to these mandatory reporters is the absolute opposite of a pattern of abuse. To give full context, I want to say that abuse is happening. Shouldn't you hear from every doctor who touched these kids during this alleged period of time in the information? And I don't know who the prosecution is going to call, but names to look for, starting in January 19, 2011, are medical staff at Centennial Hills Hospital where Amaya was taken. Medical personnel at Desert Valley Pediatrics where Anastasia was taken. Medical personnel at Summerlin Hospital where Ava was taken. And we're not even out of the first 2 months from the adoption. And this is going to go on all the way through the end of the allegation period in the complaint of November of 2013. Will we hear from Dr. Duan, who looked at Anastasia? Will we hear from Dr. Bernstein, who saw Ava? The Summerlin Hospital, who saw Ava? Will we hear from Dr. Nyarko, N-Y-A-R-K-O, at the Children's Specialty Center, who saw Ava and who noted in his notes, positive for Crohn's markers? Will we hear from that doctor from the state giving you all the information? Will we hear from the hospital personnel who looked at Ava about inflammation in June of 2011? Will we hear about all the unannounced home visits, the crossover, when DFS personnel were in the home consistent with when the foster kids were there, looking around, seeing things? We're not even out of 2011 yet. Will we hear from Dr. Maletti or Dr. Sheik? Will we hear from Monte Vista Hospital? Will we hear from any of these people who are all going to admit to you that they are mandatory reporters? And that none of these individuals personally or felt that there was any reason to suggest that there was abuse in the household. Dehydration from lack of appropriate amount of liquid would be a pretty easy thing to spot and an anomaly that would require a mandatory reporter further inquiry. The evidence will show that the Solanders incurred personal expense to ensure insurance, necessities, and ultimately the behavioral school that you heard about to help these.
Law&Crime Network. I'm Heather Hansen, and I broke in from that opening statement in the Solinder case because I want to talk to Julie before she leaves about these 3 cases that we're now going to have that we're covering tomorrow. We've got the Solinder case, which we were just watching. We've got the George Burch case with the Fitbit testimony and the defendant testifying, which is unusual.
Right.
And then we have the Donald Smith penalty phase. Let's take each one of them in turn. What do you think is going to be the most important part of the Solinder trial? You think she'll testify?
I don't think she'll testify. Look, the defense's arguments are riveting. I mean, I guess they shouldn't be arguments because it's opening statements, but I really thought he did a fantastic job. But I think we already have heard from various witnesses, including, I believe it was the nanny, who's established pretty graphically that there was abuse going on in that house.
Yeah.
So I'm not sure that, I don't think she's going to testify, and I'm not sure where the defense is going to be able to go in trying to disprove, not that they have to, but there's going to be quite a lot of evidence against her that's going to be able to establish that she is not guilty of one or more of the counts that she's accused of.
Yeah, that one's probably less of a whodunit or more of a slam dunk than the George Burch case.
Right. Right. I think, the one thing is, I mean, I guess they focused a lot on the bathroom issues with regards to on the Solinder case.
Yeah.
So is it possible that someone's going to come in and explain that, some of the tactics that were used were the right
normal,
tactics when it comes to teaching kids how to do this? Maybe, but I think most jurors are going to have a little trouble with with that type of testimony.
I agree. I think the Burch case is going to be really interesting because it's always interesting, and you were saying that you would love to get to cross-examine a defendant.
Love to not any defendant. I would love to cross-examine this defendant just because based on what we're talking about so far, I do admit that I find the story that is supposed to be coming out from him to be quite implausible.
Unbelievable. Yeah.
And so, I would enjoy cross-examining. Keep in mind, one juror, that's all you need for him to get either a hung jury or, anyone who even buys a piece of what he's selling. So that, to me, is going to be the biggest, most important part of this case. And if Doug Detry testifies, it will also be quite interesting.
With both of those witnesses, the lawyers who are cross-examining them have a tough job, a fun job. It's fun. It's a fun job, but it's also hard because there's so much. And so then you can get caught up in the minutia, like this doesn't make sense and this doesn't make sense. And sometimes the jury can be like, okay, we get it, or just get lost in sort of, again, not seeing the forest for the trees.
Absolutely.
So you really need to be focused and precision-like, almost like a surgeon, exactly where you want to go to make your cuts.
Absolutely. I think the prosecution always wants to corroborate all the evidence that has come out so far to establish that it is his DNA. The GPS is right. Like, you want to do and make sure through this defendant that all the pieces of the evidence that you've talked about so far are established to be true by him. And then pick apart his testimony in regards to why he's not guilty, and also make it very clear to the jury that there's one person in the courtroom who has the most to gain and the most to lose by not telling them the truth, and that is the person that's on the stand.
Yeah. Oh, it sounds like you are ready to cross-examine.
Oh, I'm ready. I could do it right now.
We should act it out right here on Law&Crime.
You'll play Mr. Burch.
Now, I want to just wrap up this little segment with, what do you think about Donald Smith? Do you think he will testify? And what do you think is going to be the crux of the defense's attempt or valiant effort to try to keep him from the death penalty?
I think that he will not testify. That's my guess. I think you may hear from his mother and some family members, because we certainly heard from the mother in prior interviews in regards to how much she loves her son and how much she didn't, ever expect him to commit this type of crime. I think that the type of evidence you're going to be hearing is going to be focused on his mental health, and I think that is what the defense, in a sense, should be focused on, because if you in any way can establish for the jury, not that he's not guilty, but that somehow because of his either mental disease or defect or something wrong with his brain, that could be even just a piece that would allow the jury to allow him to stay alive.
But the thing about that, Julie, is in these types of cases with sexual predators, too much of that may have the jury saying, if he's that sick, he's incapable of rehabilitation and therefore most amenable to the death penalty.
I agree with you, and I think that any argument you make can work in different directions.
Yeah.
If you, however, make it that it's less about Donald Smith and more about the disease he suffers, then perhaps the jury will in some way, I don't mean find sympathy, but spare his life because of that. I think that it's going to be extremely tough. I think that this is an incredibly compelling case, but I believe you do have some jurors that are not, very focused on giving him and don't necessarily want to give the death penalty in any case.
In any case. And that's why I think that the timing of this is really fascinating, because the Parkland shooting, Nicholas Cruz is certainly going to be facing the death penalty. And to see whether or not it's something, because when I look at the Donald Smith case, I say if there was ever a case that someone was going to get the death penalty, I would think it would be this case. Some may say the same thing about Nicholas Cruz. And so to see whether jurors in this day and age, given all that we talk about with the death penalty, are really willing to do that when push comes to shove, it's going to be interesting.
I agree with you, and I think, look, I mean, the timing is kind of telling and tragic at the same time, because I think that we will be looking at potential death penalty with Cruz, although I do think he is a younger individual,
That's right.
19 years old, and I think that there's going to be much stronger evidence in regards to mental disease, not such that it gets him out of this crime, but somehow gives some explanation for why he exploded on that day. I don't know.
Right.
Whereas Donald Smith seems to have lived his entire life
That's right.
preying on these children. And some of the testimony that came out, including the comments that were made while he was
in jail. Oh
incarcerated,
my God. And the jury coming back in 15 minutes doesn't bode well for him either.
well, there was no defense, so all they had to do was sign guilty. But I certainly think when it comes to, one of the things the jury wants to look for is remorse.
Yes.
And so when you listen to what he had to say in the jail cell in regards to basically that he would do it again, that it does not help him, and the defense needs to make some explanation as to why the jury should spare his life.
Yeah, it's one more question before I let you go. Do you think the fact that he has been in jail before and has been released gets in during the penalty phase?
That's a great question. It shouldn't, because that's really look, it's a failure of the system in many ways, that allowed him to continue to prey on these young individuals, because he had been in and out, I think, since the 1970s.
Yeah, his first lewd behavior. I don't know if he actually spent jail time, but he was first arrested in the 70s.
So he's definitely, this has been in his blood for many years. Also, what may help him is, my understanding is that he had tried to get some mental help very, very, very few days prior to the death of Cherish Periwinkle.
Yeah,
and so
if
that
that's
may
established,
help him in regards to the jury seeing him not as human, but perhaps saying the system failed Cherish Periwinkle along with the defendant, and therefore we're going to spare his life.
Yeah, the only thing about saying that is I would be concerned the system would fail again, and that this person might get back on the streets. All of this is tightropes.
You're absolutely right, although I think most jurors, most intelligent jurors that are sitting on this case know that if he is found guilty, he's never getting out of jail. And I think the question really is whether it's life or death.
Yeah. Julie, thank you so much for being here with me. We've had some tech issues, and you were a trooper through it all, and I appreciate it, and I'm sure we'll see you back here later on this week.
Thank you so much.
All right, ladies and gentlemen, we're going to go back to that opening that we all agree was really a fabulous opening statement, maybe tilted a little bit into an opening argument on behalf of Ms. Solander and the Solander case. We're going to finish that up as we wait for them to go live back in the courtroom in the George Burch case.